Hello everyone, let's begin. So I will start from here in today's video, a comparative analysis Droit system. Droit administrative law. Under the French system of administration of justice, a landmark event occurred when Napoleon took over the power of administration and became the consul general in late 18th century. You may have heard about Napoleon Bonaparte. So he was a ruler and he was a very I will not say a very great warrior, but he was a warrior who fought various wars and then he took over the administration system. And under him the administration system was going smoothly, I tell you. So he was a very good administrator as well. Napoleon took over the administration and then the French system of governance, it changed radically. To exercise judicial powers, there existed the king's court called Council du Roi. So you see, a separate court was there which was associated with the powers of king, and that was basically the judiciary organ. That was set up as a judiciary organ and its function was to look after the the king was having the judicial power in his court, that was known as Council du Roi. This court played an advisory role to king. As I told you, it was associated with the king. So it was not a full-fledged judiciary as it is in today's date. It was just an advisory organ that would give suggestions to the king as and when required. Ordinary courts, on other hand, were much neglected and their salary was dependent on the fee collected. So whatever fees or whatever fines were collected, that defined what could be the salary of the ordinary courts, not Council du Roi, because it was the king's court. As a competitor to king's court, they started developing an attitude of putting brakes on schemes and programs of government. Hence, reforms brought about by Napoleon had two objectives: to usher in as quickly as possible socio-economic movements in country, and in this process, if there is any dispute between an individual and government departments, it should be decided as quickly as possible. Hence, the court was disallowed from putting a spanner in wheels of administration. So you see, बहुत जल्दी काम करवाना एक method था Napoleon का, that whenever he is making any legislation or any rule, when he is framing, he needed to implement it as quick as possible. And also, if there is any dispute by chance between a person of the country and the government or any of the department of the government, then that dispute should be resolved. That dispute should also be resolved as quickly as possible so that those ordinary or the lower courts may not interfere in between the smooth administration process. Likewise, king's powers were also curtailed and king's court was abolished. Now what happened? When there was a competition, because ordinary courts saw that our salary was almost negligible and king's court was very full-fledged, because obviously it was the king's court, it was the advisory council to the king. So now, as a competitor, they started developing that if a legislation comes, we will be checking upon it and we will cut short it, means we will amend it or sort of such things. Because of which then Napoleon decided that his legislations will be implemented as quick as possible, and if there is any dispute, then that will also be resolved as quick as possible so that these may not interfere in the implementation process. And now what happened? King's powers were lessened and the court, the advisory court to the king, was abolished. New system evolved a paradigm shift from conventional judicial decision making. So new system was a great shift from the traditional or conventional system. Special courts had been established to expeditiously dispose the matter pending by this system. Now special courts were made so that if there is any dispute, then that will also be resolved quickly. France had evolved a dual system of justice operating on same land, governing same set of people in the same constituency. So there were those ordinary courts, and then there were the special courts established to dispose of the disputes quickly. So now France had a dual system of judiciary. There were two different courts which were ruling upon the same group of people on the same land in the same constituency. While an all private parties dispute found its way in civil court, a dispute between a private individual and government departments nearly always went to the administrative courts. So all private means अगर citizen के बीच में dispute था, then that would go into the civil court. And if there is a dispute between a citizen and the government or any of the department of government, then it would go to the administrative court. Because government department जहाँ पर इवॉल्व हो गया, मतलब कि वो कुछ एडमिनिस्ट्रेशन से रिलेटेड है, तो वो मैटर्स जाते थे एडमिनिस्ट्रेटिव कोर्ट्स. और सिटीजन प्राइवेट इंडिविजुअल्स के बीच में जो डिस्प्यूट होता था, दैट वुड गो टू द प्राइवेट कोर्ट, सिविल कोर्ट. Highest administrative court was Council d'Etat. Initially, when this system was established, direct filing of cases was not allowed. Court could only entertain petition when minister had forwarded the same to the court, and decision of court could have only been of advisory value for the minister. So now the highest court of law at that time in France was by the name of Council d'Etat, and directly matters had not gone to this court. Highest court में directly matters file नहीं कर सकते थे लोग. Whatever the minister forwarded to that court, whatever matter, whatever petition minister forwarded, that means a government official forwarded to the court entertained or took over those cases only, and whatever decision, whatever verdict the court delivered, that was only a sort of advice or suggestion for the minister. And if it's an advice, then the person may or may not implement it. Criticism. Now, what was the criticism of this system? Professor A.V. Dicey denounced this system as being where no justice was possible. While in theory, Dicey's renunciation appeared reasonable, in practice it is often rightly pointed out that this system of justice was far more efficient than its contemporary common law systems. Now in theory means when we read it in books and we just read about it, when we don't implement it, then in official papers or in books, it appeared to gain a lot of criticism, and it appeared that this sort of system, justice system, could not be reasonable, and it cannot be just for everybody. So it gained criticisms. But in practice means when this system was actually implemented in France, it was practiced in France, then it appeared that in practice the system was far more better and efficient than those systems which were prevalent in other parts of the world. In 1872, government passed a decree known as Blanco Decree, by which this Council d'Etat was made an independent system of court where direct filing as well as open hearings were now allowed. So now in 1872 there were slight changes with how the matters this court would deal with. Council dietat by this decree called Blanco Decree. Now this council dietat can deal with the matters which were directly filed into the court, or open hearings, transparent hearings were also allowed. Hence, speedy administration was a characteristic of Droit, and an institution created by name of tribunal desk conflict was to decide where different types of cases were to go, whether to the civil law court or to the administrative law court. Now, to differentiate between the matters and to decide that where these disputes would be carried upon to, so that there is not a great pendency of cases on a particular court only. So cases were differentiated, that this case is related to this matter, go to this court. Like we do now, civil cases, civil court. Criminal cases, criminal court. We do it now also. So this was to ensure speedy administration basically, and speedy resolution of disputes also, because now the cases were not only pending upon a single court, but they were distributed into various courts of law. And for that, for differentiating that this is a civil law matter, so this will go to civil court. So to differentiate such things, another branch was established, that was tribunal desk conflict. Okay? And now we come on to effectiveness of Droit. Notwithstanding the legitimate theoretical objections, it cannot be denied that this system gave some of the most revered doctrines of administrative law. So Professor Dicey criticized it. There were various objections on part of theory of this system, but then too in practice it was the most efficient one. So we cannot deny the fact that this system do give some doctrines, some very important doctrines. Doctrine of legitimate expectation, wherein the court recognized due governmental liability in case the promises to citizens were not honored. So legitimate expectation means the government is expected to, if the government is making a promise to the citizens, then it is expected that those promises need to be fulfilled also by the government. And if the government is not honoring or is not fulfilling that promises which it made to the citizens of the nation, then it has a liability, it has a duty to do that in the earliest. Okay? So it recognized the government duty, liability means duty, government's liability or duty to fulfill the promises, to honor the promises that it had made to the citizens. Legitimate expectation may arise if there is an express promise given by a public authority. If it is a public authority, it comes under the definition of government or an official who is working on part of the government or any of the governmental department. And if he is making an expression, a promise to the citizens, then that is a governmental promise, and now it is a duty on part of government to fulfill that. Because of existence of a regular practice which claimant can reasonably expect to continue. Now there was a system which was regularly continuing, and it was going on regularly, it was practiced regularly. Now the citizens expected to go on, to continue further. So now the government's duty is that you need to continue it further. Like if there is some funding from side of government to the people or to a school, like earlier the population was not so great, and so there were not many people, and there were not many schools and colleges also which were established at that time, if I talk about. So if there was a school and government did funding for the school, for some of the works of that school, and it was a regular process, a regular gradual process that took place from 10 to 15 years or so. So now the people will expect that this should continue further also. And now there is a duty that arises on part of government to honor that promise. It's not like an express promise जानबूझ के बोला गया नहीं है, but you can say it is an implied thing, because it was going on, now you need to continue it further also. Promise can be of two types, express and implied. Express जो आप बोलते हैं, I promise you I will give you a gift if you pass with bright colors in your final exams. That is an express promise. Expressly you are saying that I make a promise of this or that thing. That is an express. Implied is this second one, that because the practice was going on regularly for a certain reasonable period of time, so now the citizens expect that the practice will continue for further in future also. That is implied. Such an expectation must be reasonable. Obviously, everything should be reasonable. It should have a valid reason to be continued. Doctrine of proportionality. The classic definition of proportionality has been given by Lord Diplock in R.V. Goldsmith, when his lordship it's not R versus Goldsmith, when his lordship means the judge. Earlier judges were said as lordship. So his lordship rather ponderously stated, you must not use a steam hammer to crack a nut if a nutcracker would do. Hence, proportionality broadly requires that government action must be no more intrusive than is necessary to meet an important public purpose. So whatever the purpose or the aim is, if there is a small action that could do that purpose, you don't need to exaggerate the situation. Are you getting my point? Like we say, no, एक छोटी सी सुई से भी हम कोई फटा हुआ कपड़ा सिल सकते हैं, तो तलवार का यूज हम क्यों करें? That's what it is written. You must not use a steam hammer to crack a nut. हथौड़ी की जरूरत नहीं है एक नट को तोड़ने के लिए. If a nutcracker can do that work. So a small thing can do a work. You don't need to exaggerate the situation and do it in a complex way. Whatever public purpose you have to fulfill, you do what is necessary at that time to meet that requirement. That is proportionality. जितना required है उसके हिसाब से करो. ज़्यादा करने की ज़रूरत नहीं है. You must not be exaggerating. जहाँ सुई की ज़रूरत थी वहाँ नहीं, हम थोड़ा अच्छा काम करेंगे, हम तलवार यूज़ करेंगे. That should not be the thing. Proportional. For example, the law mandates university to take action against employees who absent themselves from duty without application. So for the employees it is making this for the people who are working in the university, not for the students, mind it. University now takes out a law which states that if the employees do not give a leave application beforehand, then they cannot be absent from their duties. There is a person A who is not coming since 1 month and did not respond to show cause notice. Means a person is not coming from 1 month and he has not told that why, what had made it, what had enabled A to come to his duty. His services are terminated. Another person B was absent for one day, and next day when he reported for service, he was issued a show cause notice. The relationship between fault and action taken in both cases explains the doctrine of proportionality. So you see, the person A was absent from 1 month and he was not responding or replying to the show cause notice which was given to him by the university authority. But when the person B who was absent for a single day, and the next day when he came to the university, then he was given a show cause notice that why were you absent yesterday? And he replied to it. So you see the proportionality. शो कॉज नोटिस दिया, रिप्लाई करो, बात खत्म. ज़्यादा टर्मिनेट करने की ज़रूरत तब पड़ी जब उसने 1 महीने का लिया और बताया नहीं, रिस्पॉन्ड नहीं कर रहा. हमने पूछा तब भी रिस्पॉन्ड नहीं कर रहा है. Doctrine of governmental liability. This basically determines that on what basis government will be held responsible for violation of another's right. Such liability is based on the twin assessment of fault and risk. So governmental liability is decided on the basis of that how or on what circumstances government will be held accountable and responsible if it had led to violating another person's right. Conclusion. After a holistic understanding of this discipline, which pertains to administration and its functioning, it can be concluded that in modern time it is absolutely essential to constantly analyze and check the administrative processes to ensure that it does not fall prey to deviance from prescribed guidelines and established practice. It means that in the modern times it is necessary that we keep a check and we constantly on regular intervals we monitor the administration process, we keep a check upon it, we analyze that what all they are doing so that the things may not go out of hands, so that the system, the governance system may not move out of the prescribed guidelines. We have seen that study of administrative law is an appreciably substantive addition to study of constitution. Concepts like rule of law, separation of powers are the basis of advanced legal study today. In addition, principles of natural justice ensure that administrative law becomes a bridge which connects the bare text of law with justice and fairness. सिर्फ लिखने से तो काम नहीं चलता ना, उसको इम्प्लीमेंट करना पड़ता है. So the bare text of law is just like some written statements which have no value until and unless they are implemented, they are brought into practice. So with the help of administrative law, the principles of natural justice, we did 2 maxims also for this. So the principles of natural justice becomes a bridge that those bare text of law can be used and everybody is provided with justice and a fair treatment is done with each one regardless of any discrimination. So here we have completed the chapter, and next chapter, next video.